not necessarily even in the legal profession, I think within the country and overseas. Karibu Senior Chacha, we are glad to have you. Mwalimu Njaramba also needs no introduction, academician of many years and a member of good standing. Karibu Mwalimu. Dr. Ogada, equally, very little introduction, always smiling when he's not fighting, but we are glad to have you here today. I can say that I grew up with Ogada in Eastlands, and when I was in Umoja, he was in Isili, and I know the kind of metal that is made of. Karibu Ogada. Then we have Barbara Maloa. Barbara Maloa has shattered all ceilings, not just the glass ones, but even the board ones. She sits in the Legal Affairs Committee of ODM. She's also a member of the East African Law Society as the organizing secretary, if I'm not wrong. She also sits as a member of the Advocates Benevolent Association, among many other titles. She says she's single, but she told me not to say that. So back to the list, we were expecting His Excellency Mike Mbuvi Sonko, who says that he's still caught up in court. He'd have wished to be here with us today, so we can only wait and see if he gets time to show up. Then I'll skip Professor Kivutha Kibwana. He came in the morning session, and therefore we are not expecting him. We are also joined by Senior Counsel Mr. Ahmed Nasir Abdullahi, also needs no introduction. I'm told he's called Grand Mullah, and I don't know where exactly he got this name from. Senior Chacha, where exactly did he get this name from?
I earned it.
Sorry?
He earned it.
Oh, he earned it. Yeah. I'm told there's conflicting interpretation of the word Grand Mullah. Some say it means a lot of money. Some say it's something Islamic. But that's a story for another day. Then we have Ms. Wanjiku Gikonyo, National Coordinator, the Institute of Social Accountability, that is TISA. Then we have Mr. Happy Olal, is a representative, CBO. Mr. Cyrus Maweu, Kenya National Human Rights Commission, she'll be joining us in a short while. And of course, like I said, the moderators are Evans Ogada and Barbara Maloa advocates, members of the public, members of the profession, karibuni sana. Welcome to this session in the afternoon. Asante.
Good afternoon, ladies and gentlemen. After such a heavy introduction by my brother George, allow us to get into the business of the day. George has managed to introduce to us who our guests today are. Allow us to give you the biographies of each and every of our guests. By pecking order, we will start with Senior Counsel Ahmed Nasir Abdullahi, or the Grand Mullah, as is commonly known. He is an alumni of the University of Nairobi, having graduated in the year 1990. He did his Kenya School of Law diploma in the year 1991. He attained his master's in law from the Cornell University in the year 1992. Senior Counsel also is the chairman of the Senior Counsels Committee. He is a former representative of the Law Society of Kenya to the Judicial Service Commission, as well as the publisher of the Nairobi Law Monthly. S.C. Karibu, welcome.
Thank you very much.
Thank you, sir. Next, we have the gentleman-in-law, our senior, Mr. Chacha Odera. Mr. Chacha Odera has a very long CV. I only think Professor Magoha has a longer one, but we'll try to make it shorter for purposes of today. Mr. Chacha Odera is, of course, the managing partner of Oraro and Company Associates, Advocates. Mr. Chacha, like myself and the Grand Mullah, are from the University of Nairobi, where he gained his Bachelor of Laws degree. He is also a holder of the Kenya School of Law postgraduate degree. In addition to being an advocate of the High Court, he is also a member of the LCIA African Users Council and a commissioner for oaths and a notary public. Now, apart from his practice, Mr. Odera is also an adjunct lecturer at Strathmore Law School, and he has chaired a variety of ad hoc committees of the Law Society of Kenya, namely the Committee for In-House Counsel and the one that was responsible for Code of Conduct. He has also served in various capacities in the Political Parties Dispute Tribunal and the Council for Legal Education. Mr. Odera is also a passionate philanthropist and is currently an honorary member of the Rotary Club, Milimani, as well as a Paul Harris Fellow. He serves as a trustee of the Matibabu Foundation and the Msaada Kenya Trust. Welcome, Senior.
Thank you very much.
Good afternoon, everyone. Allow me to introduce Dr. Njaramba. Karibu Mwalimu. Dr. Njaramba is a senior lecturer at the University of Nairobi and is also a partner at Wanyaga and Njaramba Advocates. He is a graduate from the University of Nairobi, holds an LLM from the same university. He is a registered patent agent and chairman of Jamii Yetu initiative. He is also a member of the East Africa Law Society and International Association of Sports Law. Karibu Daktari. I don't know if Miss Gikonyo is online. Ms. Wanjiku Gikonyo is the founder of the Institute for Social Accountability. She holds a Bachelor of Business Organization degree from Heriot-Watt University, where she graduated from with distinction. Ms. Gikonyo, karibu. Mr. Happy Olal, joining us in this panel this afternoon, is a member of the civil society and a fighter and defender of human rights. He's also the convener of Social Justice Center Working Group in Kenya. Welcome, Mr. Olal.
We are also joined by Mr. Cyrus Maweu. Mr. Cyrus Maweu is from the Kenya National Human Rights Commission. Kenya National Human Rights Commission is the gap between we, the citizens, and tyranny. So when you see Mr. Maweu around, he is our guardian and our knight. Mr. Maweu, welcome.
Thank you very much.
Now, to start us off, we have to put this discussion in context. Our theme is the gains and challenges on access to justice and the rule of law in the counties. We have 47 counties in this country. So basically, devolution has been touted as one of the most important and decisive factors for the future of development in Kenya. Devolution seeks to undo centralized government that has its historical roots in the colonial era. Devolution is the process of transferring power from the central government to the lower regional government. Access to justice basically means different things to different people. Access to justice in the narrowest sense may mean a guarantee to remedial mechanisms such as access to the court or alternative dispute resolution. Access to justice in this sense is an enabling right that enables the enforcement of other right claims. Access to justice in the broader sense may denote an engagement with a wider social context of governance system and systematic barriers faced by different members of the community. The rule of law, ladies and gentlemen, is an expression constantly on the people's lips and is equally not describable in one way. According to Dicey, those of us who are familiar with Dicey's writings, the rule of law could mean that no man is punishable or can lawfully be made to suffer except by a distinct breach of law. That if you want to punish me, there has to be enabling provisions of law. Secondly, that as a characteristic of a country, not only that no man is above the law, but also that we have to respect the law. So that the rule of law in the second sense means everybody is treated equally and we have to obey the law. The third rule is not important, but nonetheless it says that the rule of law is the foundation for rights, and which are then used to evaluate the quality of laws produced by the legislature and courts. With that background context, what are the problems that bedevil us with respect to county governments? We have a plethora of problems. I will mention only three: inadequate funding, endemic corruption, inadequate transparency and public participation. And that will lead us to our first question today. And this question is directed to Senior Counsel Amenasir Abdullahi. SC, in 2 minutes, do we have adequate capacity insofar as administrative justice is concerned in the counties?
Yes, thank you very much for inviting me, and also that animated introduction that was written from here. And I think firstly, let me say that this is a very important topic, I think, for discussion this afternoon, especially access to justice in the devolved unit, in the context, of a third world country, raises issues. But I think before I go into the gist of the issues, I think we need to appreciate that access to justice has two ends. And I think we always emphasize just one end, and the common traditional end, which is that, whether they are courts, whether they are infrastructure, whether they are all these other issues, whether people have money, whether I can, get justice. But one thing that we have not done very well in Kenya, which the big problem is, even after you access justice, in the traditional sense, in that you have litigated a matter in court, you have had an opportunity to instruct a lawyer in the judgment. The biggest problem we face in Kenya now is that even when you have a dispute, you can't enforce it against the government or against, many bodies. And when you can't enforce justice, there are many Kenyans who are very millionaires but can't enforce judgment. And the government, according to what estimate, has about 3 trillion shillings in claims. So I think that's one thing we should never lose sight of, and that's also very common in the county government, is that when a plaintiff or a judgment or someone has a judgment, he still doesn't have an opportunity to enforce the judgment against the county government or the central government. So I think that is one important thing we need to understand, that we have just, this can't be enforced and you can't realize. So I think we should internalize or contextualize this issue of access to judgment in terms of execution or getting the fruit of the judgment. And that is a big problem in the government. When we come back to the traditional issue of capacity, I think also that's a big problem. Most of these counties were counties that were neglected in the last 6 years. Most of them don't have basic infrastructure in terms of this. Most of them don't in addition to the challenges you face in Nairobi, they face so many challenges. I mean, the big idea of, an adversarial litigation in this county, where the traditional form of settlement is huge problem. Can be right for a clan clash once in a while, because when you take someone to court, for example, where I come from, I mean, people will think that it's one clan that has declared war on another. So making people understand this model or this foreign form of system itself poses a challenge. I think that's how I will take my first 2 minutes.
Okay. Thank you, SC.
The second question is directed to Senior Chacha Odera. Senior, you've heard what my co-moderator said earlier, that some of the challenges that he mentioned, some of the challenges that faced the rollout of devolution. With regards to that, in your view, what are the challenges in counties insofar as their provision of access to justice is concerned?
Thank you very much, Barbara. First of all, let me clarify that I'm not a senior counsel yet, but I see George wishes me well, and with his encouragement, maybe I might one day just be conferred that coveted title. When it comes to the issue of provision of access to justice, especially down at the county levels, first thing we must recognize is that the courts for a long time have been seen as a receptacle through which justice trickles down right up to the citizenry as individuals or as communities. The Constitution, as was drafted, one of the things they didn't devolve the judicial function or the court system. So the judicial function still remains part and parcel of the judiciary within the Republic of Kenya. Though, to be fair, the judiciary has done quite a bit in terms of being able to provide facilities aligned as against the counties. Unlike the past where we didn't we didn't have courts in all districts or high courts in all particular districts. Presently, there is a deliberate effort by the judiciary to trickle down high courts and the magistracy right up to the county levels. And this is really informed by the need to also have the devolved units provide or have a platform upon which people can access justice. But having said that, we must first of all recognize that justice is not merely the infrastructure, the buildings, or the personnel who are sent to those particular buildings. In the context of a devolved system, first and foremost, the devolved systems, which in this particular case will be the county governments, must first and foremost appreciate and understand the purpose for which they were created under Article 174 of the Constitution of Kenya. One of the things which worries me, and I think it worries many other people, is that devolved systems have merely, in many times, been taken to be, the primary aim was merely to devolve the bad habits that were there when we had one unitary system, being the national government, now being devolved to the 47 counties and carrying their bad habits from the national government as a unitary unit to the 47 devolved units. And one of the things which you see is without any legal framework, you'll first of all find heads of these units, who in this case are governors. First of all, they're your excellencies. That's the first thing which they did. Secondly, they got themselves motorcades. And in spite of the very fact that when it comes to mundane things like even traffic, they have taken it upon themselves that they must also behave the same way the President of the Republic of Kenya is entitled to behave by law. So what do? They have a motorcade, they throw people off the roads, And with that kind of habit, and why I come to that very basic thing is the first challenge that I identify is the challenge that even those people, those officials, or those office bearers who are tasked with running these devolved units, if they cannot understand the basic things like adherence or observance of the law, then we're in trouble. Many county officials are unaware of their responsibility to protect human rights, and human rights is something which is extremely wide. And when it reaches a stage when one does not have respect for the law, then one will not really be expected to even know what human rights are in order to respect them. And that, of course, also leads to there's the lack of information as to what the objectives are. And, the ability to socialize themselves to the fact that Article 147 was very specific as to their purpose and objects. Their purpose and objects were not to create several small little fiefdoms within the various counties to where they reign supreme. There's also the lack of public participation and inclusion in the many things they do. That was a problem which we had when we had a unitary system where we only had a national government. And it was assumed, or it was intended, that as it trickles down to the county government, it will be the citizenry will have a much easier way to participate and to be included in managing their own affairs. Budgetary constraints are there, but a lot has been spoken about these budgetary constraints. But even before we talk about budgetary constraints, I think it is important that as Kenyans we must address what are these county governments doing with the little money that they are getting. Today, whenever you read the Auditor General's report, you find all sorts of misuse of these funds. So even before we talk about enhancing that amount of money, what one should be talking about is interrogating and auditing what are these units doing with the money which they are being given. And if that money is being given, being allocated to them, are they using any of it to enhance access to justice or matters related thereto? To be fair to some of them, they have been good in terms of donating land, but that doesn't need a budget, doesn't need any more money. All it does is allocate land to the judiciary, and the judiciary has the money to put up the infrastructure. So even before we make too much song and dance about lack of funding to the county governments, I think it's important that as a nation, we need to look back and ask ourselves whether the little that the county governments are presently getting, how is it being applied? And in the context of the discussion this afternoon, how is it being applied for the provision of access to justice? There's the issue of poor empowerment strategies. Many of the county governments, I am not sure whether they do have, as part of their strategic plans or as part of what they intend to do in their 5-year cycle, is empowerment of various, whether officials on the one hand or the members of the public, so as to be able to socialize the people in knowing that the right to access to justice as a human right is a right and not a privilege. So for now, I think, for now, that's what I have to say with respect to that particular question.
My friends from the Somali in the north to go for Masla, Senior Chacha who comes from Uholo, Republic up in Siaya to go for Sing Rock and all those practices? Have we broadened access to justice platforms?
Thank you, Uganda, and thank you for having me here. I think the tragedy that we have as a country on matters devolution is that we tried to copy everything at the national level and take it to the county level. And of course, that tragedy is made even more serious by the fact that the justice system is still, we may say, judiciary assignment, so that now the counties may not have a direct role to play. And that's why whatever counties may do can only, as you have said, be deemed alternative dispute resolution mechanisms. However, the counties have failed to take what we call traditional dispute resolution mechanisms seriously. And why I say so is because the idea behind devolution is that whereas we are also talking about devolution of funds so that they can be used at the county level, the idea behind devolution is that there are also certain things that are special to certain areas, to certain counties. And those are the issues that the counties would have taken into consideration to say that in this particular area, there are certain things we can do, for example, that we can make people deal with their disputes and therefore deny the judiciary customers. But then all that counties do, as has been said, is that they give facilities for the judiciary to construct more courts. So that now it's a matter of saying that there is no alternative other than just having cases going to court, and the only way the counties can facilitate is to give facilities for such cases. And therefore, in a manner saying that they haven't explored how else they can actually avoid their constituents from going to court and utilizing other mechanisms like the traditional dispute resolution mechanisms. And even before they go to traditional dispute resolution mechanisms, even other ADR mechanisms, counties should be at the forefront to educate their constituents on how such things happen. So now it is possible that people in a certain locality can be able to actually avoid going to the judicial system. And for the same reasons that we used to say that, for example, in the judicial system there is backlog. In the judicial system there are other things that are unexplainable to the ordinary mwananchi. For example, they will not understand why a case which was black and white has been thrown out by a court and so on. And therefore, it is incumbent upon counties or county governments to actually pass the information or even educate their members, and perhaps even set up certain structures to ensure that alternative dispute resolution mechanisms are used at the counties, rather than just facilitating the judiciary to have a facility within the county, which is basically just saying that they expect that cases will still go up, as opposed to saying that we have our own internal mechanisms or our own local mechanisms to ensure that we do not have to use the judiciary. And therefore, to that extent, counties have really failed. Actually, perhaps I'm only aware of one county, there may be others, that is doing something about a policy on ADR. So there may be others, I'm not sure they are, but there's only one that I know of. And therefore, they have generally failed on that, and perhaps they should do better. Thank you.
It appears that the counties are really getting a flack for not doing much. Barbara, you are on with the next question.
My next question is directed to Ms. Gikonyo. And can you confirm if she's online? Good afternoon, Ms. Gikonyo. Please unmute your mic. We still can't hear you. Unmute. Emily, could you unmute her? Great. Good afternoon, Ms. Gikonyo.
Afternoon.
Just speaking from what Dr. Jaramba has said on the issue of exploring alternative dispute resolution by counties, he says that he feels counties have failed to take traditional ADR mechanism seriously. My question to you is that what is your view on that? Do you agree with him or do you disagree? And the second question is in the context of emerging realities under devolved governance, given what your foundation does, TISA does, can the culture of the rule of law be nurtured? Over to you.
Thank you so much. Thank you for this invitation and the opportunity to share and to speak about a subject we don't normally deal with from a different perspective, because we look at public participation from a governance point of view. And so I think I'll try and answer both the questions in one. And I'll say I'm not sure we can blame the counties around ADR, because as pointed out earlier, the judicial function is a national function. And during the conversations after the promulgation, when the CIC was still on the scene and thinking through how do we implement the devolution laws, the responsibility for developing the policy around ADR was tasked to the Attorney General, and I believe this would fall under the Attorney General working together with the judicial arm of government to develop the policy, and then to this policy, and I'll try and indicate how I see this working with the counties. First of all, I'd just like to stress that devolution transfers, the Constitution transfers powers not just to the county governments but to the people. Article 1, sovereignty of the people. Article 174C, self-governance to the people. So devolution anticipates a context where we don't take centrism from the national and create it at the county, but we really empower the people. Is this happening? I would say no, not to that extent, but there are gains so that we don't bash the counties. The data shows us that in terms of service delivery, in terms of development, the counties are making an impact. The government's own data, the national government data shows, especially in the agricultural field, much as the amounts given to agriculture has been falling in absolute terms, in relative terms I mean, the impact of agriculture to the GDP has been rising because of new technology, increased emphasis, hiring of extension officers, because counties are on the scene, because this money has actually gone closer to the people. We are also seeing these gains in ECD. We are also seeing gains in health, even though there are some aspects of health that have been negatively affected, partly because of the ongoing industrial disputes, and also some small governance issues around procurement, around vaccination and things like that. So there are challenges, but overall we are seeing the impact of devolution. And this happens in a context where devolved governments are actually getting a smaller share of revenue than the local authorities were getting. Local authorities prior to the Constitution were getting up to 27% of the national revenue share. Counties are now getting 17% of the national revenue share. So counties are doing much more with less. And this is where I would want to say that we are suffering on ADR. It's the resistance at the national level, because before, ADR was really being, in practical terms, at the local level, you'd find ADR either through the community systems, through civil society programs, or through the provincial administration. The chiefs have played a very important role in ADR, albeit, and developmental agencies. Government pays very little. So despite evidence that communities are driving their own development, actually government puts in barriers so that you have laws that constrain properly organized civic engagement. So this is a very important conversation that needs to bring all stakeholders on board so that we can really orient our mind to empowering communities and giving them an enabling framework. But the responsibility and the buck starts with the national government. Thank you.
Thank you very much, Ms. Gikonyo. She has treated us to a mixed salad. On one side, struck a very positive note in the sense that she says the counties are servicing a lot and there's a little bit of impact with a little bit of money being.
A need to be more active in filing strategic PIL cases, not only where there are violations, but even to secure constitutional principles and standards for the greater good of this country. Thank you.
Thank you for that, Mr. Mawiu. On to our next panelist, Mr. Happy Olal, a member of the civil society, the activist in the house, to a ground, as Kenyans like to say. This question is directed to you. Is devolved governance adequately shielded by the Constitution against any clawback of the authority by the center?
Thanks a lot for inviting. One thing that I usually ask myself is that when we look at the county government, we have the county assembly, we have the executive, but we don't have the judiciary, the aspect of the county government. So you'll find that even when people are not getting proper services in their respective counties, they have to go to sue the local county at the national, the judiciary is still national. So I think the judiciary should also have been devolved so that when the people of Mathare don't have water, they can go to a county court and sue without going, the national court sometimes is very difficult. But if we have a county executive and we have a county assembly, we should also have a county judiciary to deal with issues of social justice, because this is the smallest unit of governance. So I think there's a lot needs to be done still to make sure that we protect the counties from going back to centralization that we have been trying to run away from. Yeah, that's my comment for now. Thank you.
Thank you very much, Mr. Happy Olal. According to Mr. Olal, watu wa ground wako saa sana, kuna vile they are not very happy. To Senior Counsel Abin Nasir Abdullahi, Mr. Olal casts a mournful tone, and I will want to rehash the question that Barbara posed to Mr. Olal to you. Is the devolved government or governance adequately shielded by the Constitution against any clawback by the center? And while you examine that question, I will also want you to consider this following question. Why is there a gap between our rhetorical commitment and the daily practice as concerns access to justice? Over to you, Senior Counsel.
Yes, thank you very much for those questions. Again, there's always the theoretical perspective and, the empirical or the factual reality on the ground. If you look at, the theoretical point of view in
second question was, why is there a gap between our rhetorical commitments and the daily practices as concerns access to justice? The gap.
Yes, again, I mean, that is, I don't think that is something peculiar to the county government, and I think that's not something we can even ask the county government to comment on it, because as one of the panelists rightly said, I mean, the justice system is basically centralized. It's a central government function. It's not a devolved unit. So, I mean, the county governments have not been very rhetorical, or they have not been theoretical about it. And when it comes to the daily practice, I think that is not for them. But let me add this from a national point of view. I mean, you know, it is good to write good laws or even good constitution, but the proof of the pudding, as they say, is in the eating. And whether we observe access to justice or we practice it in our daily practice is really something that the country as a whole has a very yawning deficit. You know, there's a huge deficit in terms of the empirical reality, in terms of the practice of access to justice. So there's that gap. I mean, the gap is very big. It's both at the national level and the county level between, the fanciful pronouncements and the sad realities of access to justice. But I think there's also a question where the county governments, how they help the courts. But there are many times, and I've seen this from a practical point of view. Last week I was in Narok, and when they opened the court, I think the judiciary does not have enough budget for furniture. And one of the judges was telling me that the county government went out of its way, to give them a budget for buying, infra-court furniture for the magistrate courts or even the high court. So, although it is not really their core mandate, the county governments have gone out of their way in many counties to give land for courts, to help even the infrastructure, and even to furnish, because all the county governments know how important the courts are and how helpful they have been to their constituency. So I think in terms of helping the judiciary, especially when they have a budgetary problem, the county governments throughout the country have been very helpful in trying to, help their constituencies to access justice and for the judiciary to build the courts or to provide certain aspects of important infrastructure. Thank you.
Thank you, Senior Counsel. My next question is directed to Senior Chacha. Senior Chacha, you are a
Press itself by way of matters being filed before it. And as one of the earlier panelists had mentioned, I think it was my good friend and student, Mr. Maweo, that Article 22 is an article which is available to all persons to approach court where a right has been violated or threatened to be violated. There was the discussion of what we have seen with respect to the transfer of various functions of our county government in Nairobi to the Nairobi Metropolitan Services, and also with respect to the lease of the medical equipment, which, as you all know, has been subject of Senate inquiry. But even as we talk about, firstly, the transfer of functions, and then secondly, about those medical equipment leases, one of the things which, as citizens or as members of those various county governments, we must ask is, first of all, starting from the transfer of functions. From what we have seen, there was some instruments which were signed transferring those functions. After the execution of those instruments, and much later, from both the main media and from this alternative media, There were all sorts of allegations as to how those instruments were executed. If you're a county government, how are you being straddled with these onerous contracts, which belatedly you are telling us were not for the good or for in the interest of the counties? We need to get much more aggressive governors who can prevent this clawback. We all know that power being exercised by various institutions, there's always tension between exercise of that power. And each center of power must jealously guard its space. So in this particular case, even as people have this discussion, I think we also must throw the challenge to our county governments headed by governors. What more are they doing to prevent this clawback of authority by the center?
Dr. Jaramba?
Kile kina mwanzo lazima kiwe na mwisho. My friend Salome Odero is smiling. I come from the same part of the country as her. Swahili is always difficult for us. Tempers fugit. We have to put this to an end. I'll want to invite very brief comments from Mtwango Mtani, Happy Olal. I'll start with you. What is the future for access to justice in the context of devolution? Mr. Olal, 2 minutes, short and sweet. Has he disappeared? You know, his name means the disappeared one. Are we with Mr. Ms. Gikonyo? I felt a tingle. I almost contributed. Do we have Mr. Olal? Mr. Olal? He's not yet back. We move on to Mr. Maweu. Final parting shot.
Thank you very much. I will just point out that legal problems are an everyday occurrence, and one just needs to walk into a police station or a courtroom and see how many people are really struggling, trying to resolve their dispute, at the same time even trying to understand how the legal system functions. That should make access to justice a concern for all of us.
Outside what I may call the mainstream judicial system. Not that I have a problem with the judicial system as such, but it is an alternative that perhaps would work better for people who are neighbors, for people who are in the same community, who would continue living together. Thank you.
Thank you very much. Viewers, Mr. Njaramba is first and foremost a commercial law expert. So for him to give us public law talking points, that is applaudable. Thank you very much, Dr. Jaramba. To Mr. Chacha Odera, the future of ADR in Uholo. Uholo is Eden on earth. Where do we go?
Thank you very much, Evans. ADR, as Dr. Jaramba has said, that where especially we live in communities, where we must continue living with each other.
Appreciate it. And I'm sure, as some of these counties open up, we'll have more robust court, we will have more legal representation. And insofar as I think I can see in the next 5, 10 years, the future of access to justice in the counties will be very bright, and even the quality as we go on will improve. But as some of the commentators rightly say, that
Okay, it's noted. We'll call him and thank him. And Mr. Mawiu, thank you so much for honoring our invitation. We also don't take it for granted. My